hearing the dulcet tones of Lynn Pillay takes me back to those very happy days between 2005 and 2008 when we were getting ready for government and she was the chair of the Justice and Electoral Select Committee, and how we enjoyed working collaboratively and positively together on the electoral finance legislation. It was one of the thrills of my life, and I regret to say I was the one who was responsible for pulling the national members out of that select committee visit to Australia because we do not believe in trips like that are primarily vacation. I remember receiving the itinerary from Ms. Pillay and I was so disappointed that I think there were 2 or 3 meetings a day, and she and her colleagues were going to be holed up at the Hyatt on the park. They were going to be travelling business class across the Tasman, where I believe people should fly economy class across the Tasman. So I said, well, I'm sorry, but the national members are required at home serving the people, and so we pulled the trip out. But nonetheless, I do acknowledge the honourable member and say the Sentencing Council, which was an appalling edifice designed to straitjacket judges into giving particular sentences, is now consigned to the trash heap of history, just like the electoral finance legislation. But I do want to say something about Part 4, because Part 4 contains some very interesting general provisions, and they relate to claims made in arbitration, limitation defences and other enactments, contracting out of defences and the pleading of defences. And I just refer honourable members to Clause 41, which is actually almost one of the more fundamental principles of the bill, because it says that if a defendant establishes a defence against a claim under the Limitation Act, then the court or tribunal cannot grant the relief sought, but the claim itself isn't extinguished. So one's prevented from bringing the claim, but the claim is not extinguished, and that's at the very heart of what this limitation legislation is all about. The other interesting part of Part 4, and I don't know that I've ever seen it before, is that the 1950 Act is going to be with us for many years. So the 1950 Act is amended and then repealed, and the Acts specified in the schedule are consequently amended, and these are the important transitional provisions that officials worked very hard on to knock into shape. But I don't think I've ever seen a situation where an Act is amended and then repealed, but it's going to continue to apply to claims relating to events before 1 January 2011, but it will require claims to be brought by the later of 15 years from the date of the Act or omission, or 5 years after the new Act commences. And that's why clauses 23A to 23D are included, because what they do is they bring across into the 1950 Act provisions relating to the long stop and that discretion to allow relief, for example, for an action of abuse of an infant or the gradual process injury that we've been talking about. The only other point I'd make, and it's good that the law finally is clarified in this country, relates to Clause 53, and that is going to provide that the clause will apply to a civil proceeding before a New Zealand court or tribunal whenever the substantive law of a foreign country is to be applied in that proceeding, and it provides that the limitation of that foreign country is part of the substantive law of the country and must be applied accordingly. For many years there was academic debate about whether limitation law was procedural or substantive, and the Choice of Law Limitation Periods Act 1993 of New South Wales and the Foreign Limitation Periods Act 1984 of the UK clarified the point for those jurisdictions, and it is now clarified here. Note also Clause 54 about the public policy exception for limitation law of foreign countries is to apply except in relation to Australia. So Part 4, as I say, contains some very important transitional provisions, the reason for that being that the legislation, Mr Chairman, the 1950 legislation is going to be with us for many years to come.
I call the Honourable David Parker.